Good morning, everyone. Welcome to our 84th Best Practice Series seminar. We have three outstanding programs. My name is Rob Litz, and it's really my pleasure on behalf of all of us at USA&M to present these seminars. We've wanted to have another employment program for some time, and as you know, over the years, we've had an emphasis on various ethics programs, and we have two really terrific ones to present it today. I want to thank Kelly Spiller, who has put this on in the back of the room and doing all the organization and does just a fabulous job for us. Also, I want to thank all of you. With your contributions today, it's allowing us to make donations at this important time of the year to Legal Services of Eastern Missouri, to Land of Lincoln Legal Aid, the Kornblum Food Pantry, and to Beyond Housing, four nonprofits who are always in need of our dollars, our volunteer time, and they really help our community. And it's really all of us who are assisting those important folks. I also want to thank all of our speakers. We have a jam-packed program, and I want to refer you to their bios at the back of the material that was sent to you. This morning in our leadoff on our employment section, Jessica Liss. Jessica manages both the St. Louis and Kansas City offices of Jackson Lewis, is an outstanding and experienced attorney in the employment, labor, and management side. Jessica is also a member of the Federal Court Eastern District of Missouri ADR committee. Jacqueline Zimmerman is an attorney on the plaintiff side and represents employees in a number of employment matters. We were just joking, she's part of the UMKC Law School St. Louis alumni chapter. Jacqueline is also a member of the ADR committee in the federal court. Ellen Harmon is a very experienced attorney and currently working for the largest medical emergency provider globally. But Ellen is also the newest member of our mediator panel at USA&M. She brings her law degree, she brings an MBA, and she brings a registered nurse degree to her background, and will do just a fabulous job mediating a variety of cases with us. The three of them are going to present on employment law. What I would like you to do is, if you have questions, they'll take them at the end. And without any further ado, I'll hand it off.
Good morning, everyone. Thank you so much for joining us today on our discussion about valuation of employment, litigation, and claims. We're going to be talking today about the changes that you may have seen in recent times in the past 2.5 years since COVID on valuation of them, and hopefully discuss how to settle them and litigate and for the benefit of successful mediation. As Rob said, I'm Associate General Counsel for Global Medical Response, and I'm new mediator here at USA&M. I'm very happy to be joining this panel and look forward to working with some of you in the future. Jessica Liss and Jacqueline are going to be joining me today for this discussion, and they're going to bring their unique perspectives on how they value cases. Jessica has represented employers as a managing partner at Jackson Lewis for how many years now? Many years. And Jacqueline is a founding partner for Ponder Zimmerman, and she's going to share with us her perspectives on plaintiffs' views. And they're both active litigators. They've both tried some cases in recent years, and they're going to share some of their thoughts about those things. And we're going to talk about how COVID and the subsequent things that have happened since COVID have impacted the valuation of claims, damages, and past and future wages, even medical costs have changed some during that duration. We're going to start with pointing to Jacqueline here. Jacqueline, you've had the benefit of trying several cases throughout the pandemic. What do you believe, what impact has COVID had on jurors and their perspective on damages?
Well, as we all know, COVID, right or wrong, sort of became a very hot political topic. I think a lot of people had a lot of opinions about it one way or the other. During this time, people were off work or looking for jobs. And I think jurors, I found them to be maybe a little bit more opinionated when it comes to trials. I've noticed voir dires, during voir dire, they have a lot to say, a lot more to say, a lot stronger opinions on things. I think, and this, I wouldn't say we've mentioned before angry jurors, that some of them have seemed like they've been a lot angrier about certain things. And I think that's true. Luckily, we've had the benefit of plaintiff's verdicts in the cases that I've tried during this time. But during those trials, I've noticed that after talking to the jury afterwards, a lot of them had a lot of strong opinions about not liking what they perceived as the defendant sort of downplaying the plaintiff's injuries. They sort of took offense to that. Now that could just be specific and anecdotal evidence from my experiences trying cases during this, but they do seem to have a little bit quicker to see the plaintiff's point of view and look down a little bit on defense counsel or defendants sort of dragging things out and not taking their injuries seriously.
And Jessica, what have you seen from the employer's perspective?
Sure. So there's a reason we don't try a lot of cases. Juries are unpredictable, and I think they've become more unpredictable since COVID. And to Jacqueline's point, people are anxious and angry, and they say that an employment case is the one single case where most every juror has experience. Not everyone has been in a car accident. Not everyone has a medical malpractice or criminal case. Everyone has been an employee or an employer. So they cannot set aside their personal beliefs. So there's been a lot written in the insurance space and the claims space about nuclear verdicts. There have always been large verdicts, particularly in the city of St. Louis, even St. Louis County. Statistically, those numbers across the country have gotten larger. But sorry, Jacqueline. The good news is, I think like the economy, 2021, things were, some people did very well, some people didn't. There's been discussion that those nuclear verdicts should stabilize in the next few years and reach a normalcy or come back to a plateau. But I agree with Jacqueline that like all Americans, people are getting more comfortable speaking out loud, speaking in a veneer setting. I've often been stunned at what people are willing to say in public, in front of strangers, and it's becoming more so about their own personal experiences. So I think for at least the next 12 to 18 months, you're going to continue to see increased unpredictability in verdicts.
And Jacqueline, you mentioned about angry jurors. Is there anything in particular that you've noticed that has inflamed the jurors?
I guess it depends on if we're talking about like before in voir dire, things that inflame jurors. Gosh, it's cut both ways. You get the kind that are inflamed about any kind of lawsuit whatsoever, and we always get them. They don't, they think all lawsuits are frivolous, and people, like Jessica said, people seem very willing to speak up. I feel like jury panels now, everyone's talking, you get an opinion out of everyone, which is helpful if it's in your favor, but at least who you're getting rid of. But we still get there's too many lawsuits, inflammation, where people get very upset about that. Specifically to insurance companies, even if we obviously don't bring up the insurance situation in voir dire, but sometimes jurors will bring it up. Is there insurance? Is there this? And they get mad if they think insurance isn't paying out about something. Like sometimes jurors will just bring that up. because I think a lot of people have had experience with insurance companies denying a claim for an auto accident or home or something like that. I think that that is a topic that I've heard more of lately. They'll bring it up themselves. Like I said, after we've polled the jury or talked to the jurors after a trial, it's the same sort of thing. There seems to be a lot more jurors getting offended by why didn't they just pay something? Like, why are we here? You know, why have they been denying this injury? Why have we gone out? Why did this happen 5 years ago and they're still not paid? So even if it hasn't been a huge verdict, I've seen them more be like, why are we even here? Like, why didn't this company just pay for this? Why didn't they just, you know, take care of this a long time ago? You know, why have they been sort of downplaying the injury and now we're all the way here? So that's what I've been hearing from jurors.
And you're talking a little bit about delays, which leads us into our next question. And Jessica, could you talk a little bit about the delays? The courts shut down for a long time. And how has that impacted cases and your valuation of the cases?
It you know, justice delayed is justice denied. I think that affects both sides. You know, pre-pandemic, we could talk about damages, let's talk about lost wages. That's within everyone's control. Before, what have you done to mitigate your damages? You assert you were fired, you know, go try to mitigate your damages. And that's our burden. That's the employer's burden to demonstrate that they have failed to mitigate. Well, with COVID, we all lost the control. We all lost the ability to understand. People might have not been an essential worker and been furloughed, been forced to stay home. Perhaps they were vulnerable and had health issues. And we all know that unemployment benefits were extended. So the lost wage claims, you know, it's very difficult to value because you're looking at perhaps an 18 to 24 month period of time where you're feeling your way around a dark room in terms of, did someone truly just abuse benefits and stay home, or did someone exercise their rights to accept unemployment benefits, which they're certainly entitled to do? That shouldn't be the employer's responsibility and liability if you truly accepted those benefits and, you know, were unable or unwilling to go back to work. So the damages claims, the hard costs have become difficult to value. If you are an hourly wage employee in a business where there's a need, manufacturing, warehouse, nursing, that argument falls a little flat because we know that there are still many available jobs. So you're arguing issues that are truly COVID related that end up becoming the plaintiff and the defendant's responsibility and burden to navigate. We did not see that pre-COVID. So there are new issues that get raised in the assessment and analysis of a damages valuation.
And Jacqueline, when we met before, you mentioned that some of your clients had talked quite a bit about the job market and availability. Could you address that for the group?
Yes, obviously right now, there are a lot of job openings in certain sectors and a lot of sectors in the economy that don't have enough workers right now. So there are jobs out there if people want to find them. And this is not necessarily pre or post COVID, but it's so different than when I started practicing at the end of the 2000s in this type of law where the economy wasn't as good and they would lose their job and they would be out for a while. Now there's jobs to be had now that we're a little post COVID, whereas we're not so much in the scenario anymore where some people were furloughed and laid off or couldn't work, like Jessica said, for various reasons. There are jobs opening now. I will say one of the things that I found with my clients, at least in my experience, and maybe because I just tell them they have to, they've been pretty good at getting jobs and attempt, trying to find jobs. I will notice though that some of the type of work that my clients have done post-COVID, and I think this is probably a trend just nationwide, they've taken on different types of jobs, like opening their own businesses in some, like their own childcare center or their own what else have people done? I've had some people do some very unique things that is bringing in income, because once they got laid off from their other job and started working from home or various other things, they've started new types of careers. They, didn't go back to the old job that they had, which also, I guess, kind of factors in if they're starting new businesses. Some of their income starting out hasn't been as high as it would be, but they just use this as an opportunity to sort of go into a different direction with their careers. So it's just been a very unique time, I think, for the job market and employers and employees.
So as we move into discussing litigation here, post-COVID and trying to settle those claims, when you're going towards a mediation, how have you handled, managed your plaintiff's expectations?
Always, as a plaintiff's attorney, managing expectations is always difficult. I feel like I've gotten better at it as I've gotten more experienced. TV doesn't help. Advertisements that show constant, giant verdicts or giant settlements never help me out very much, because I have to explain to people those are unique situations that have nothing to do with you. But I think that I start early managing expectations, letting my clients know that this is not, you're not good. Unlikely you're going to get some gigantic jury verdict in a big win. So usually going into mediation, I try to explain to them the law as well as I can to a layperson that, this is what you're entitled to in a plaintiff's case. You're not entitled to millions of dollars of punitive damages. And that doesn't necessarily mean post-COVID. That was, now that there's a cap on it, I have to explain that to people. So I have, and getting back to the employment market, I always explain to people that they have a duty to mitigate, that they can't just sit at home and watch their lost wages rack up, waiting to get a settlement. It doesn't work like that. So, and I think most of them have sort of understood that. But going into mediation, I really do try to parse out the categories of damages and tell them dollar figures that would be reasonable to sort of get them in a window before we get there and mediation goes off the rails. So,
and Jessica, from the employer's standpoint, it's almost the exact opposite. You're needing to let your clients know that verdicts may be a lot higher than they were previously. How are you managing their expectations so that you can go into a mediation and settle successful,y and explaining to them how they may need to put a little more money on the table than they would have pre-COVID?
Right. Despite our best intentions, I think employers are coming to mediations with less money. I think there's a new perspective. I think we all had to kind of throw out the playbook. There's a reason folks don't physically come to mediation all the time, because the employer, that costs money. And I think employers, while they appreciate being able to come by Zoom, it's because there are costs associated with that. So, for the mediators out there, I do always encourage you to understand who the employer is. I know there's a lot of emotion in Jacqueline's room. There's an equal amount of emotion in an employer's room, big, small, for-profit, not-for-profit. They too have some trauma associated with COVID. And I think they're coming with maybe a little less patience and an equal amount of emotion. I was starting to say, I think mediators should take a minute to do some research on the employer. Have they just furloughed 4,000 employees? Have they had a series of reductions in force, to just understand the economic climate of the employer going into it? Sure, there's insurance sometimes. Sometimes there is, sometimes there isn't. So valuing it from the employer's perspective, there's a lot of stakeholders. There are carriers, there are, general counsels like Ellen, there are folks that she has to respond to and report to. So just again, for the mediators, recognize that there's 5 to 6 people who bring their own perspective and value and high emotion to the case. So for the mediators, you've always had to be active listeners. I think you need to be more of an active listener and understand that, you know, employers have been challenged also over the last 24 months.
And Jacqueline, regarding managing plaintiffs' expectations, what can mediators do to help you?
To help me, I think what I've seen some mediators do, and it is very helpful, is to back me up and reiterate to my clients sort of sometimes on their best day. If they win at trial on their best day, this is the most you're going to get. Like sometimes my clients can't even wrap their mind around that. Like they think that that's all, they're gonna go to a jury trial and just, you know, get a $3 million, you know, verdict. And so why are we talking small numbers, or, you know, they don't. So mediators who really explain to my client the process, you know, even though I've explained it to them, I think sometimes a second voice helps them out a lot to sort of understand the process and damages. That's always been effective. Like Jessica said, emotions are high everywhere. My clients take this very personally, and they have a very hard time because they feel like a lot of them have been fired. They feel like they have been personally offended, you know, by like in their soul, like I've been a good worker. Now I am personally offended by this. It's affected my family, and I feel, you know, like they insulted me with this. So one of the big things that always happens is every time, even though I warn my clients, they're going to come in, the first offer is going to be small. Inevitably, they get super offended and want to just leave, you know, like every time. And I have to always talk them down off of it. And so it's helpful if mediators can sort of explain, you know, that too, that there's a negotiation process, that we're here to work through the day. The first offer isn't, you know, it isn't meant to be offensive. It is, well, it might be, but don't be offended. we're gonna get through it. So it's just, you know, I deal with a lot of tears in my room a lot. There's just a very high personal feeling that they have. So trying to separate the emotion from the reality of it, I think is something a mediator can help with. And while recognizing their emotions, but that this isn't a good decision to base off emotions. This has got to be more of a business decision for them instead of an emotional one.
Okay, and Jessica, I think your firm has handled litigated several cases post-COVID. Can you talk a little bit about what you've been seeing?
Sure. I guess I would first start by raising the employers who implemented mandatory vaccination programs. Many employers on the front end, you know, were advised how to analyze those, the risks associated with them, how the federal government was going to win or lose, particularly for federal contractors, how that was going to play out in the courts. So there was a lot of levers being pulled, and for employers that did implement mandatory vaccine programs, they went in eyes wide open, and sometimes at their own peril. There have been a flurry of charges, religious accommodations and medical failure to accommodate a medical need in the mandatory vaccine context. I've not seen them come out of the EOC yet. I probably have a dozen or so on my desk at the charge stage. And I think the EOC and the Missouri Human Rights Commission, you know, may have office policies about how they're going to handle those going forward. It will be interesting to see how that wave of litigation plays out, to the extent there are right to sues issued, and we are navigating then how we litigate the mandatory vaccine programs, when at the time is a very hot button issue, and then now that we're exiting or living a more normal life, and vaccines are becoming a bit more common, you're litigating an issue in the rearview mirror. So it will be interesting to see if and how those claims are litigated and how they'll be valued. I think that is going to be a real challenge. What the value of losing a position because you know, elected not to get vaccinated, but your employer has a lawful, legitimate reason for implementing the mandatory vaccine program at the time.
Thank you. And Jacqueline, I believe that you've tried a couple of cases post-COVID. Can you talk
Yes.
a little bit about that? And then I'm gonna ask you a little bit about whether or not you tried to mediate prior, but go ahead and talk about the cases.
Okay, we have tried a couple cases post-COVID after a long wait with no trials. And I sort of have touched on this already. Like I said, we saw sort of juries with a lot of opinions. Jurors who didn't want to be there because they didn't want to sit next to people. We still had a lot of that going on, very COVID related, didn't want to be, you know, right next to strangers all day.
Were you masked?
Huh? We were not masked. This was post mask mandate, which I was glad for. I think it's hard when people are testifying and asking questions. You can't hear them very well. So it was post mask, and none of our participants, our witnesses, wanted to wear a mask, but some of the jurors did, and they were still voiced concerns during voir dire about being there. Some of them that had health conditions that didn't want to sit there. Like I said, we just heard a lot of opinions. People were very outspoken on issues. We did, like I said, in both cases, we had plaintiff's verdicts, and they were sort of mad at the defendants in both cases. And it was a St. Louis County case and a St. Louis City case. So I've tried one in each county since COVID has ended. And it's just been a different landscape, I feel.
Were the verdicts higher or lower than what you would have expected pre-COVID?
They
Or
were
the same.
higher.
They
They
were
were
higher?
higher than I would have expected, and significantly, in the first case we tried, it was a significant difference in what they were offering before trial, and we did not try to mediate that case because defendant didn't want to mediate it.
Defendant wouldn't mediate.
Wouldn't
Okay.
mediate and only offered a small amount. And we ended up with a much larger plaintiff's verdict. Now, we have since mediated that case and after post-judgment,
Post-judgment.
you know, and have resolved it, but
We did it with the Court of Appeals.
we did with the Court of Appeals. The Court of Appeals has a mediation program. This is the second time that we've had an appeal we weren't appealing it, but they came to the parties and said, hey, before you guys get into the briefing and all of this, see if we can work this out before we get into all of that. So, and Judge Gertner was the one who mediated it for us, and it all worked out. But so
The other case, did you mediate that before it went to trial?
the other case, no, we did not. It was sort of the same thing. They were offering way less than what we ended up with. So
Okay, so you did a little bit of pre-trial negotiations,
Mhm.
and you were so far apart, you just didn't even. go
Yes,
into
didn't
mediation.
even get close, didn't even go to mediation. So, you know, and in both of those cases, I think, like I said, we had much larger jury verdicts than we expected. And obviously what the defendant expected, because they didn't offer anywhere in the ballpark. So, you know, right now, like she said, juries are unpredictable, though. For the same reason, trials are so risky that I always, you know, unless it's a situation like that where we're so far apart, you know, they just make me nervous and make my clients nervous. But you know, I think so that's been my experience. We have tried a couple after a long drought of not trying any, which I think has started moving cases along a little faster too. So
Okay, it's been about 4 or 5 years since the Harvey Weinstein decision and the Me Too movement. Jessica, what impact, if any, have you seen post-COVID or during COVID regarding sexual harassment type claims?
Well, they still exist. You would think with, you know, such a large portion of our workforce not physically in the same space, they might have declined, but there are some new and interesting facts that arise in the work from home setting, and sexual harassment is occurring more in the electronic space. Many claims, or some claims, arise out of GIFs or GIFs, however you want to say it. I think it's a generational thing. Postings on social media, you know, the unintended, it was a joke, I didn't mean it. So, and you know, there's a reason why you all are muted and not being seen, because you forget sometimes you're on camera. And you know, we were laughing earlier that you don't want a Jeffrey Tobin situation where someone is doing something inappropriate and forgets that their camera is on. So there are new facts and new circumstances in which harassment claims arise, sexual and other protected activity. So those post-COVID circumstances and the Zoom, Teams, WebEx, whatever you use, have created some differences in the landscape. I would mention too, training still is best practice for sexual harassment. As you know, in Illinois, it's mandated by the Illinois department. And does training work? Is it effective? Is it effective over Zoom? Is it effective as a module? Data says that sometimes training is not effective. So we have to navigate from the employer's perspective how to ensure that people remain educated and actually understand what's expected in the workplace. So sex harassment claims still exist, but I think the fact patterns are evolving with technology and COVID.
And Jacqueline, can you tell us about any sexual harassment claims that have come your way since COVID, and anything that might be a little bit different, as Jessica has discussed?
Yes, I haven't had any specific sexual harassment cases. I'm trying to think if I've had any new ones since COVID. I do know that since Me Too, I have tried one sexual harassment case. And during voir dire, again, if you ask the jury, everyone here knows about the Me Too movement. Do you have any opinions? Because that was like right when it was hot and new, and everyone had lots of opinions. Frankly, most of them not the way I thought. A lot of people were, I think this is too much, this is, now everyone has been sexually harassed. Not everyone can possibly be sexual. There was a lot of opinions that they thought it was going too far, which obviously we want to know that before we're trying a sexual harassment case. I will agree with, there was a lot of talking on that topic, and from women too. A lot of women were not happy with what they perceived as women over exaggerating sexual harassment claims, or just kind of trying to jump on the bandwagon that was going through at the time in the media. Now I will, jumping on what Jessica said earlier with technology nowadays, almost every sexual harassment claim that I have, the case that I have right now, there are text messages that are inappropriate. There are Facebook DMs that are inappropriate, and even if it happens outside of work, I think there's such a blur now between the work life and your personal life. It used to be you would just go into the office, you'd work 9 to 5, you'd go home, you didn't have a phone, you weren't texting your coworkers at night. And I think sometimes people, they think, oh, she's my friend at work, and so they'll send her a funny haha or say something, and it's not funny. They don't see the distinction, or doing inappropriate things when they're working from home on a Zoom. There's just such a blurred line now that I think probably employers, I don't know what they really do in that regard, but sending inappropriate. I don't think people even always think they're inappropriate. They're doing it at night. They think it's a friend. There just needs to be, there's just so much uncertainty there. I don't think that employees always know where the line is anymore. It's not as clear cut as it used to be. Don't go to work and slap someone on the butt. Now it's like, don't be sending them a picture. It's just so different than it used to be.
When things are in writing, text or DM, you're not seeing the facial expressions. You don't hear the inflection in the tone of their voice. And I think what I'm hearing you say is that that's missing, and so things can be misinterpreted. But then you've got you actually have evidence
Paper trail.
as opposed to he
Yes.
said, she said.
Yeah.
There's that impact. So Jessica, can you speak to that a little bit?
Right, my knee-jerk reaction, you still have elements, right? Was it unwelcome? What really was the impact on the person? And to your point, you don't always know. And sometimes people will use that after the fact. It wasn't unwelcome when it was received and probably got a like. And we're all having to interpret how did it land? What did the like mean? What does the smiley face emoji mean? Does that mean it wasn't unwelcome? So you're applying technology to the same elements. You still have prima facie case you have to get through. So it's not easy to navigate electronic data in a sexual harassment case, and it's not easy to mine it. For those with teenagers or tweens, you also now have apps that encrypt information, and it doesn't exist anymore. So again, from the employer's perspective, litigation is expensive. It's always been expensive. It's getting more expensive because you have to get forensic experts to extract data from phones. You get any discovery request or a lit hold or an e-discovery request, and it has a lot of implications and unintended expenses. So to extract data from this to support a sexual harassment claim is really expensive, and it's why we come to USA&M and use mediators to avoid that cost.
What are the challenges, Jacqueline, that you've experienced in trying to get data such as that in order to preserve it?
It's electronic data, like she said, it's just so complicated and expensive. It's part of it. You have to just, hope you're getting it all. I know that sounds silly, and it's just, you don't know what's out there. So you don't know if you're getting everything that you need. Everyone has these cell phones, and it goes back to what I said, sort of the blurred line. Like if you're an employer and you have a phone, or you're an employee with a phone and it's not even a work phone. So, your employee just has his personal phone, but he's using it to text his coworkers dirty jokes, and then he gets rid of that phone. It's hard to grab who had what, especially if they're not necessarily a manager or anybody in charge, or it wasn't a work issued phone. It's their own personal, or they're using their personal computer to send Facebook messages. Now coworkers are all Facebook friends, and so you have to watch what you're posting on your own Facebook page, and tracking down those people and their personal items is difficult to find. Oh, well, we don't have him anymore, and we have no idea where his personal cell phone is. He got rid of it, or that was 4 phones ago. I'm like, I think from them keeping track of that type of electronic evidence, they may, employers may not know necessarily who was using what where to send this kind of information. So it's just, it's difficult.
And I will add this, Jacqueline, close your ears. There are services that are fairly reasonable where we have the ability to cast a wide net and call someone's social media accounts and look at all of their postings. Now, there are some obstacles when it's private. Sometimes you can get past that, but for a couple $100, you can see all of the social media, whether it's Instagram or Facebook or all of them. It's very helpful, and this is why good plaintiffs attorneys like Jacqueline will say, after she signs them up, stop using social media, please. If you haven't already, stop.
Yes. So I'm always advising my clients, just unless it's like a picture of your grandbaby, like just don't be putting anything else up there. Because I know you guys do that stuff, and I'm like, because they dig deep, and I'll be like, any meme you post, if you're trying to say that you're being sexually harassed, but you're posting dirty memes all over your Facebook page, or half-dressed pictures of yourself, stop. Let's just keep it as neutral as humanly possible if you're going to use social media at all, because otherwise, they're finding out what you're saying.
And not to lose sight of the facts of law, but it also is helpful to demonstrate what might be unwelcome. If this is someone that is, posting inappropriate things on a regular basis, you're left with an argument that, well, that little GIF maybe isn't unwelcome in the context of their social media life. If it is a grandmother who you just see dogs and puppies and rainbows, you can make the argument that that absolutely was unwelcome, but if it's somebody who's a bit more open with their life, the unwelcome element, you have some latitude, with that argument.
Let's get back to damages a little bit here and talk about the actual assessment of damages. And have you seen any differences post-COVID in actual like medical costs for any of your clients? We'll start with you, Jacqueline.
Well, mostly doing employment work, I don't see a ton of medical costs. Most of my clients, what I see a lot is they don't seek mental health care because they've been fired. And so then they no longer have health insurance. And so they don't typically do it. As far as the ones who do, typically they've probably already either been in or have had therapy in the past. I feel like a lot of people that are more comfortable with it are more likely to do it. So I really haven't seen a huge change in medical costs.
And the medical costs.
I mean, maybe it just hasn't been long enough out yet where I can see any kind of a pattern going forward. We're just now sort of crawling out of the post, we're kind of getting out of it where everything's getting back to normal. I didn't see, but I personally haven't seen a huge change. I know a lot of people have switched to more of a online therapy, doing Zoom sessions with people instead of going in, but that doesn't really change the value much. It's just been a new way of people getting therapy without having to actually go somewhere, which is, like we're doing right here. So that's been a big change overall.
Is that pretty much the same with you?
Yeah, I agree that the value, the hard costs haven't changed in a meaningful way, but as a society, we're all more comfortable with mental health issues. I think Jacqueline's struggle is the plaintiff's struggle is always going to be, what part of your life do you want to be discoverable? If we all, as the daughter of a psychiatrist, if we're all more comfortable talking about depression and anxiety, I think plaintiffs are going to say, sure, yes, I've had depression, I've had anxiety, and being terminated has exacerbated those conditions. And again, we're talking about this in a COVID context. Was it losing the job lawfully or unlawfully, or was it because we all had anxiety, medically diagnosed, real or perceived? That cannot be evaluated with a scalpel. I don't know how you can dissect mental health issues over the last couple months about, was it because you lost your job, or was it because we were all home, baking bread, cleaning our closets, being anxious about the world? It's hard to attribute that to the employer. And I think getting back to jurors and valuing cases, I think that's going to be difficult for both sides and mediators when you're trying to argue, my depression was exacerbated because I was terminated. Was it? That's where the medical documentation is going to be a strategic decision of whether or not you want to put that out into the world and litigation.
Yeah, my clients typically don't want people rooting through their medical files. So we typically just stick with the garden variety emotional distress so that they can't go rooting through their medical records, which, for whatever reason, like Jessica said, losing your job is going to be stressful unless you're just independently wealthy and don't care. For almost anyone, even if you already have a depression level of here, it's going to probably bump it up a little. It's certainly not going to make it better. So, I think I've always thought jurors can figure that out. Like, they have some common sense. They know if they've lost their job, so they're going to assign some level of monetary value to the additional stress and anxiety that losing a job is going to do to someone. Now, I know during COVID, a lot of people were home, like you said, baking bread, doing puzzles. I did a lot of puzzles and knitted, which was weird. But I think, people that were terminated for a reason that they felt was discriminatory or otherwise, have that as, I think it's understandable if that would cause some additional stress. If they were just home because they were furloughed or otherwise, or just working from home, I mean, I think there's a difference there, but So as far as the value, I'm not sure that the value's changed a lot, just kind of how we're looking at it,
Are you-
how everyone
Okay.
was upset, so.
Sure. So, as a corporate attorney, when we've had a couple of cases that we were pretty sure there was some significant liability out there, we've used mock trials to assess the value of a case. And it has helped in the negotiations for settlement. Have you used mock trials and have they been helpful? We'll start with you, Jessica.
I won't say we've done mock trials, in a formal sense. Things have been roundtabled, and it is astonishing how the value can oscillate. Where I have seen employers put more money is into jury consultants, for all the reasons that Jacqueline has, nicely articulated today. That if a case, regrettably has to go to trial, consultants in terms of assessing jurors in a particular venue, or physically sitting in the courtroom to assess what people are saying or how they have filled out their jury forms. That's where I've seen companies put their money.
How about you?
We have not used mock trials or jury consultants, primarily because we are a two-person, two-attorney law firm, and just, the resources. I don't want to spend, this is all coming out of my clients, it's gonna come out of my clients' award that they get, either settlement or otherwise. So it would be a hard cost to throw their way and say, hey, we're gonna spend this much, it's gonna come out like. So that's not something. I try to keep our costs down as much as possible, because everything's gonna come out of their, they're not, my clients are not wealthy people. So if I can maximize whatever they get out of it, I try. I mean, that obviously is a downfall of being a small plaintiff's firm, but we do the best we can. So it would be helpful. I definitely think, trying to pick a jury is always hard. So that would probably be the one thing. I would also be more likely to spend it on would be a jury consultant.
Okay.
Because they're just so
Sure, that makes
Yeah,
sense.
yeah.
That makes sense, that it would be more from the defendant's perspective. I personally have found them to
Yeah.
be very useful when there's potential for a high dollar
Yeah.
verdict.
So
Regarding, I see Rob is on there. Are we
Yeah.
running out of time, Rob?
1 minute.
1 minute.
1 minute. I've got one quick question for you. And this is really regarding the process of mediation. Since COVID, we've gone to Zoom. How has the use of Zoom mediations impacted settlement of cases? And how do you feel about its effectiveness? Do you prefer in person or do you prefer Zoom? There's also the hybrid, so that's kind of a complex question, but if you could just kind of address.
It's a good question. I think the hybrid is the way to go. Rob mentioned that Jacqueline and I both sit on the ADR committee for the federal court. We've amended the rules to, and I encourage you all who practice in federal court and mediate in federal court to look at the amended rules, because it speaks to whether or not a mediation can occur remotely. It gives the mediator more power, more authority. We all assume we can do it by Zoom, and the mediator can make that call. If a party disagrees with the mediator that someone can appear by Zoom, that party can go seek relief from the federal court, whether or not the party should or should not be in attendance. So I think it's effective. We get more cases resolved, meaning it gives us more opportunity to get together to talk about cases. But in light of the fact that even the federal court is amending the rules to acknowledge its strength and weaknesses, I think is telling that it's certainly here to stay.
Jacqueline?
Just real quick, I like Zoom mediations. I did several of them. And they were worked out fine. I feel like we all got them settled. But I will say, I think it's helpful for me to actually be in the room with my client, so that when the other is in the other room, my client's not alone at home stewing over and not understanding what's going on. At least I can sit there with them, with my clients who are not typically sophisticated litigators.
So you like to be in person with the mediator, with your client?
Yes, I think that's
Okay.
helpful.
That's helpful to know.
But it works.
From the mediation perspective.
I mean, they work
perspective.
with Zoom, but I just know what happens when it's just me and my client and the mediator goes to talk to the other side. They are just question after question. And I think it's more helpful if I'm with them to sort of hold their hand through it.
That
So
makes sense.
I can't agree
You have
more.
some questions, Rob?
I don't see any questions, but Jacqueline, that last comment, excuse me, I think is really important. In having the plaintiff's lawyer with the plaintiff is so important. If it's in the lawyer's office or if it's at USA&M in one of the conference rooms, I think the norm that we're seeing in terms of the hybrid being the future, Jessica's correct. Often it's going to be the insurance rep offsite by Zoom. Occasionally it's the defense lawyer offsite by Zoom. But it is really helpful, I think, having the plaintiff and plaintiff's lawyer together, if not in our office for the mediation, be together in their office. It just makes our job a little more effective. And Jacqueline, you're spot on in leaving that novice plaintiff off to themselves, who often is on their phone, and we're not looking at them, we're looking at the ceiling fan going round and round. We need to see the eye contact and the expression. So I think that's super helpful. All of you, thank you so much. This is helpful. There are new issues that are coming up every day in the employment world, and we so appreciate the information you've shared with us. And Ellen, welcome aboard. We look forward to many years of your experience in mediating cases on one side and now serving in the neutral role. We're going to take just a 5-minute break. And when we get back, we're going to talk about civility, and we'll see you in 5 minutes. Thanks so much. Our next segment is on the ethical topic of civility. Judge Renee Hardin-Tammons is not a stranger to the bench. Judge Hardin-Tammons has served with a black robe both in the municipal court, the associate circuit court, the circuit court, and I'm thrilled to say it now a member of the Missouri Court of Appeals Eastern District. She has spoken on the topic of civility based on her years of experience in the courtroom, and we can learn quite a bit from her. Joining her to moderate the program is Judge Michael Burton. Judge Burton, as you all know, was a member of the circuit bench, was the presiding judge when COVID first occurred, since has retired from the bench, and we're so thrilled that he has joined USA&M to serve as a mediator and arbitrator and in doing special master work, and has done just a fabulous job in his first month or two with us. Judge Renee, I'm going to turn this over to you. Thank you so much. We have a full hour.
Thank you very much. I'm happy to be here, and thank you for having me here today. I want to start off by speaking about what civility is. In 2017, the Civility in America annual survey defined civility as polite and respectful conduct and expression. It generally means treating others with courtesy, dignity, and respect. In our legal profession, civility means treating your opposing attorneys, the litigants, the judges, the court clerks, the bailiffs, your colleagues and co-workers with courtesy, dignity, and respect, and it includes cooperation, restraint, and honesty. Some would say that civility is treating others as you would like them to treat you. But my parents brought me and my siblings up with the notion that we should treat people better than they treat us. You know, respect is a two-way street. You give it and you receive it. There are 10 common aspects of civility as attorneys that you might want to keep in mind. You want to keep your commitments. We want to seek agreement and accommodation with regard to scheduling and extensions. When an attorney needs an extension, be kind and courteous and be respectful that things do come up. Be respectful, act in a courteous and cordial manner. Be prompt, punctual, and prepared. Maintain honesty and professional integrity. The court will appreciate it, members of the public will appreciate it, and opposing counsel will appreciate that. It's a good idea to communicate. You know, it's nothing worse than when you call an attorney and they don't return your phone call. So it's important to communicate with opposing counsel. Avoid actions that will that they're just taken merely to delay or harass the other side. Ensure proper conduct before court. Act with dignity and cooperation in pretrial proceedings. Act as a role model to the public, because the public is watching. Members of the legal profession, when you're in court, they're watching everything you do and what you say. Mentor a young lawyer. Utilize the court system in an efficient and fair manner. Why should civility matter? Well, there are some damaging consequences when attorneys act uncivil. It can lead to bar complaints. Someone could file a formal bar complaint against an attorney who is acting uncivil. The court could do it, the judge could do it. It could cause an attorney to lose clients. It increases everyone's workload. Further, it erodes or debases the legal profession. It diminishes the public's trust in the judicial system. It increases stress for attorneys, for clients, and all that are part of the system. So it's important that we, as members of the judiciary and members of the attorney community, that we act in a respectful way because the public is watching.
Judge Harden-Tammons, can I just interrupt for a second? As
Sure.
the moderator, I just want to make sure everyone understands that there is a chat option. And I think we just saw someone that is doing that. If they can make sure, if you have any questions, we're going to take all of those up immediately after Judge Harden-Tammons' presentation.
Yes, and that's why I'm trying to move on through it, because I want to give you an opportunity, if you have questions for me, that we will have time for that. Civility relates to professionalism and ethics. As you know, the Supreme Court of Missouri has the inherent power and the duty to prescribe standards of conduct for lawyers. The Supreme Court determines what constitutes grounds for discipline of lawyers. The Supreme Court also may choose to discipline an attorney who is admitted to practice law in Missouri and may revoke a license for unfitness to practice law. So it's important to keep in mind that when the Supreme Court is made aware of actions by members of the judiciary or members of the bar acting in an uncivil manner, the Supreme Court could take action. Incivility in the courtroom by the judge can also be a problem. There's a famous or infamous case involving a judge by the name of John Murphy out of Florida. This is the case of the fighting judge. This is an example of where the judge acted in a very uncivil manner. In this case, the judge and the public defender got into an argument. And so that led to the judge saying the following in open court: if I had a rock, I would throw it at you right now. If you want to fight, let's go out in the back and I will beat your expletive. The two men left the courtroom. It was a packed courtroom. They went into the back, and what you could hear on the video was raised voices and a scuffle. A scuffle was taking place. As a result of this fight, Judge Murphy was removed from the bench. The public defender in that case quit. The Florida Supreme Court stated as follows, that they were not amused by what happened. It said that where a judge's actions erode public faith in the courts, removal is appropriate. So that's an example of where a judge is acting in an uncivil manner and led to that judge being removed from the bench. Examples of uncivil behavior is name calling. I've heard it a couple times as a judge and as a lawyer. Someone says, "You are a liar." That's name calling. That's uncivil. Unreasonably withholding consent to continue a hearing or trial. Failing to honor commitments such as canceling a deposition when opposing counsel was right en route to the deposition. Denigrating opposing counsel in a brief or a motion. That's an example of uncivil behavior. In the case of Florida Bar versus Norkin, an attorney wrote opposing counsel several inflammatory emails, including the following: "When is your unprofessional, ludicrous, downright unintelligent conduct going to stop? Before or after you are directed to pay my bills?" That was found to be uncivil conduct. In Ray Madison, counsel informed the judge, told the judge this in a letter, that "I do have profound doubts concerning your fitness to preside fairly over cases." That was found to be uncivil. In the matter of Florida Bar versus Abrason, an attorney told a jury that the judge was the one that was completely disrespectful, lacking in respect, and lacking in professionalism. That was found to be an example of uncivil conduct. In the matter of Hancock versus Board of Professional Responsibility, a lawyer disparaged the judge and called the judge a clown and a bully. That was found to be uncivil. In the matter of Attorney Grievance Commission versus Frost, counsel called one judge a lawless judge and another a weak man and a corrupt judge. So not good behavior, but there is help on the way. Judge Brian Curry and Judge Kevin Brazel wrote an article about how to handle or deal with a difficult lawyer. But first, let's talk about what they are. First, you have the bully. The bully is the one that's rude to opposing counsel, witnesses, and opposing parties. They're rude to everyone. This is a good example of this would be found in the Texas style deposition. And I did not include that, but feel free to look that up at your leisure. That's an example of the bully lawyer. The next is the obstructionist. These lawyers make everything difficult, eating everything down to writing up the memo. Who's going to write the memo? Talking to the clerk about getting a court date. They're just obstructionists. Then you have the paper tiger. These lawyers generate unproductive letters and emails. They constantly send you letters and emails for no good reason. You also have other bad apples. This is a catch-all category for pathological liars, racists, misogynists, and others who simply cannot get along with others. Then you have the misguided. These are the lawyers received little or no training or were trained by the bully lawyer, the obstructionist, the paper tiger, or the bad apple. Well, we as judges, in my role, we can help. We can be the role model. Judges should be the model of behavior that they want to see in the courtroom. The judge could say to a lawyer at the very first court appearance, I intend to treat lawyers who appear before me with respect. In return, I expect lawyers to treat the court and each other with respect and professionalism. The judge should facilitate civility. Judges could emphasize that he or she expects that lawyers work cooperatively together, treat each other with courtesy, and work collaboratively to schedule time to meet and confer as needed. The Missouri Supreme Court states that a court professional shall treat litigants, co-workers, and all others interacting with the court with dignity, respect, and courtesy. The judge should be a good coach. The judge should encourage lawyers to be proactive, that they should meet before coming to court, not for the purpose for settlement, but for introduction. It may be brief. It may be saying, hey, can I meet you at Starbucks? Let's meet about 5 minutes before we go into court. Not talking about the case, not talking about settlement, but an opportunity for you to get to know the attorney on the other side. Avoid rudeness to one another. If counsel is rude, don't treat them like they treated you. Use humor to diffuse the situation. Fight incivility with kindness. Be sympathetic and solution-driven. If necessary, bring serious episodes of incivility to the court's attention, because the judge would typically may have a way to help bring the temperature down in the room. The judge should be the problem solver. If the problem is that of nasty correspondence, the judge may order the parties to meet in person. But as a last resort, the court should use sanctions. I mean, there are opportunities for the court to use a recess or confer with an uncivil lawyer or litigant in chambers or off to the side. But the court does have sanctions for uncivil behavior. That could include contempt of court. And as I mentioned earlier, it could involve a formal complaint to the appropriate bar association. There are, I'm not going to go through the case. You can read at your leisure. Gandhi Property Corporation versus Commerce Savings and Loan Association. That case sort of gives you a good set of standards for how you should deal with an attorney when you're involved in civil litigation or any type of litigation for that matter. There are some states that have mandatory civility is mandated in the oath that an attorney takes when they first become an attorney. Missouri is not among that handful of states, but Florida, Utah, South Carolina, and Arizona are among the states that have that. Some lawyers will say, I've just been a zealous advocate. I am just advocating on behalf of my clients. And so civility codes conflict or approach on my duty to be a zealous advocate. Now, I think, being a zealous advocate doesn't require you to be uncivil or unprofessional. So at this time, I want to share with you, I had a conversation with some judges about civility, and I want to share that video with you at this time.
Lawyers who display incivility in the courtroom do not persuade anyone. When they speak, their words sound like noise. Their incivility drowns out the facts and the law. Judges teach civility with their patience, their demand for decorum in court proceedings, and ultimately through their orders and judgments.
I would define civility as treating others with the respect and regard that you would expect in return. And in the context of practicing law, treating others with respect, even if you totally disagree with them, and even if your emotions are triggered by the adversity in the context of legal dispute.
I would define civility in a number of ways. I think if you go into a proceeding on the premise that you want respect, I think you treat the other side the same way. It's sort of the golden rule that we all grew up and we've been taught for time eternal. That to have civility, both sides have to show respect to one another.
Litigants and lawyers appear before a judge because they disagree about some matter. Civility is not about trying to get people to agree, but civility is about reminding the litigants and the lawyers about how they should behave in the midst of their disagreements.
Definition of civility and say it's more than just about behaving well. It's your general attitude and your outlook. As a profession, I think we should embrace a new professional norm to help us promote civility, and that's assuming positive intent. And that's more than just giving people the benefit of the doubt. That's not having the doubt in the first place. Consciously choosing to assume that somebody is operating with the best possible motive.
In recognizing the humanity of our fellow beings, we pay ourselves the highest tribute.
I believe that if members of the judiciary promote civility, they in effect promote credibility of the judiciary, and that results in increased respect for the judiciary.
So for judges in particular, we consider it very important that our branch of government be perceived as a civil branch of government, even in the face of incivility that we see in some of the other political processes. Because without it, we don't have the respect of the citizens.
No matter the time nor the place, when people from different cultures, religions, and with different educational levels and socioeconomic statuses meet to discuss their disputes, a tense encounter is presented. The courtroom, however, is the model for society. It is where disputes should be discussed without angry words, without name calling, and without disrespect being directed to the judge or to the opposing party.
Good manners, disciplined behavior, and civility, by whatever name, are the lubricants that prevent lawsuits from turning into combat.
Peace and civility closes minds. And, positive mind finds opportunity in everything, and a negative mind finds fault in everything. And we are a profession of possibility.
Incivility within the legal profession, I believe, decreases the credibility of the third branch of government. And if we allow our credibility to be decreased, then we won't be effective.
On the occasion that incivility shows up in the courtroom, it is the judge's responsibility to disinvite incivility and to remind everyone that civility is always welcome in the courtroom.
More civility and greater professionalism can only enhance the pleasure of lawyers in practice, increase the effectiveness of our system of justice, and improve the public's perception of lawyers.
Judges promote civility in the courtroom by their actions. I am mindful of the fact that my facial expressions, my tone of voice, and my spoken words could demean the profession or lead to incivility. As a judge, I speak through my orders and my judgments.
A judge must lead by example and establish proper decorum within the courtroom. think you need to refer to attorneys and citizens similarly. Don't show favoritism. I refer to both the attorneys and the citizens as Mr. or Ms.
You have to practice what you preach. You have to hold yourself accountable, others accountable. If you don't want people yelling at each other, then you shouldn't be yelling.
I think sometimes, more often than not, the parties come to hearings looking for a bargain, so to speak. And I think that's maybe partially because they have the positions they want to maintain. And they're not willing to maybe look or listen to the other side. Partially, I think it's because maybe they're not prepared, maybe they have some degree of insecurity. But to get around that by showing respect to one another from the very beginning, I think that we still reach that point of resolution by differences and still maintain the proper court decorum.
I frequently confer with the attorneys ahead of time before we go into court, especially in the context of a trial, and tell them that I don't permit incivility in the courtroom. I don't allow it at all, whether or not the jury is present.
The lawyer's duty to act with reasonable diligence does not require the use of offensive tactics or preclude the treating of all persons involved in the legal process with courtesy and respect.
So to me, the art of zealous advocacy is being able to persuade whoever it is with the rule of law and with the facts that you argue are on your side, or with arguments that are logical and reasonable in the face of settlement negotiations or mediation, but not by demeaning and disrespecting your opponent.
Zealous advocacy is civil. And if you aren't able to do that civilly, then you're not zealously advocating. If you start to get personal and make personal attacks, or you're the loudest and most obnoxious person in the room, that doesn't make you the most effective.
Zealous advocacy is not incompatible with civility. As a matter of fact, it's expected that a lawyer will make every applicable argument and point out every issue with the opposing lawyer's case, while at the same time behaving in a respectful and courteous manner.
Zeal is one of the dynamic forces of accomplishment. This is more than talk, more than declaration and perception. It is putting your entire being into what you are doing for maximum output.
I think if you begin by setting that culture in the bench, then it will flow to the parties and they likewise will treat each other with respect.
The way that we can really improve both our work relationships and our reputation individually and as a profession is by not only treating each other well, but assuming the best in one another and trying to behave accordingly.
It's going to be plain to the judge. We know where incivility comes from. We can see it, even if it's not in our courtroom, we can see it in the record. We can see it in the pleadings sometimes. And we aren't persuaded by that. Judges are not persuaded by those kinds of attacks.
If you conduct yourself properly and in a civil manner in the courtroom as the leader of the courtroom, people may not agree with the outcome every time, but they'll at least accept the outcome because you've demonstrated respect in the courtroom, respect for them, and they in turn will respect the judiciary.
All of us, judges and lawyers alike, must be the change that we wish to see in the courtroom.
So that concludes the video. If anyone has any questions, I would be happy to answer those for you as best as I can at this time.
Let me start, Judge Harden-Tammons. There was a question that addressed the fact that there are clients that hire their attorneys essentially to be bulldogs, to act with a certain amount of aggression, perhaps. Maybe they've been mistreated before, and they've seen some really good episodes of Law and Order that give some good examples of how attorneys are supposed to act. Any suggestions about how to perhaps temper a client's hopes when they come into a courtroom?
I will just speak from my experience. My experience is that clients are impressed by lawyers who are prepared, who are on time, and they're surprisingly impressed by lawyers who are respectful. Because what happens is that those lawyers who are respectful, the judge likes those lawyers, the court personnel likes those lawyers, and it shows. But when attorneys come in aggressive and unpleasant to everyone, the clients pick that up as well. So I would say that come prepared with the case law, argue the facts and the law, and you will get the respect from your clients. Your clients will appreciate that.
All right, thank you. Any thoughts about how an attorney should respond to uncivil behavior? And I'd give probably the example that we hear a lot is just complete failure to respond to requests for discovery, failure to respond to emails or phone calls. Any thoughts about what steps an attorney should take to address that?
I think it should be sort of progressive. You start off by, maybe sending a letter or making a phone call and it's ignored. You send another one, you make another phone call. You might mention prior to going in to see the judge, hey, I sent you a couple letters, I made a couple phone calls. Can we discuss the matter now? If you still have an issue, I would suggest saying something like maybe, can we meet and have some coffee? Can we go down to the cafe at the courthouse and maybe, start talking about something different other than the case? As a last resort, I think as a true last resort, maybe bring it to the judge's attention. Obviously, there are rules on the books that sort of can help lawyers deal with that. I mean, you can file certain documents, but I think that's sort of the last resort. Sometimes I've found that there are a lot of things going on sometimes with lawyers, and sometimes they're overwhelmed. And when someone sort of says, hey, how's your day today? I know you haven't gotten back in touch with me, but can we talk about this matter now? I think that sometimes tends to change the atmosphere in the room and gives that attorney an opportunity to be willing to speak with that opposing counsel.
We've all had those experiences where the attorneys judge are in the back in chambers and they're pointing fingers at each other and saying some pretty horrific things about just bad behavior. And the reputations of the attorneys, and there's one in particular that might be in front of you that is the source of the problem. But it's very difficult as a judge when both attorneys are in the back saying there's problems. How do you handle that when you're dealing with what you would describe as the bad apple, but you're not privy to all of the information that the attorneys have, perhaps, but in reality what's going on here?
I've had a situation where I've had to sort of separate attorneys and talk with them individually. And so I would take that opportunity if I saw that there was someone who was being unreasonable and sort of say, hey, how's your day? What's going on? We've got to get this case resolved. I'm not blaming you for anything, but I'm just going to tell you right now that here's what I expect.
Well, I'll leave it here, Sally.
Yeah, well, I mean, it's,
Hey, there we got that taken care of. Go ahead, Judge, I'm sorry.
Yeah, here's what I expect. I expect you to, you know, comply with my scheduling order. I expect that you attorneys will get along. I am not going to tolerate uncivil behavior. And here's what I do when I see it. I sort of, you know, start off this way and talk with each side to make sure that everyone knows what the rules are and what the potential consequences would be in the event that it continues. But most of the time, in my years as a judge, I really, after I've had that conversation, that tends to fix it. I've never been pushed to the level where I've had to file a formal complaint, but I have had, on the occasion, probably a handful of times, I've had to take an attorney back in chambers. I typically will have my bailiff or members of my staff present when this is occurring. But I typically will take them in the back and say, you know, cut it off. You know, or maybe did I misunderstand what I saw? But here's what I think I saw. And if I see it again, it's going to be, you know, you're going to force me to take some other steps that I really don't want to.
Thank you, Jeff. I was wondering, and I know myself, I would see this occasionally. I was wondering how you respond and what kind of goes through your head when you see this, when someone's treating your clerk, for example, in a very uncivil way. What goes through your head when you see that, and what do you do typically?
Well, the first thing that goes through my head, it reminds me of the childhood bully. And one of the reasons I got into the legal profession is because I don't like bullies. So something rises up inside of me, and I look at the lawyer and say, you will not talk to my clerk in that way. Okay, so I don't know, but I should go outside and come back in, and we're going to start this over again. But the way in which you're speaking is not acceptable, and it will not be accepted in this courtroom. If you cannot behave in a better manner, I'm going to ask you to leave. But first off, I want you to apologize to my clerk for your behavior.
All right. Judge, what kinds of considerations do you make when you're trying to figure out what sanction is appropriate? You described earlier on in your presentation that it's a graduated process, that you don't talk about sanctions initially, but when do you get to that point where sanctions are appropriate, and how do you decide whether or not to be addressing things on a contempt basis, reporting to the bar, or any other way of addressing things like that?
You know, as I mentioned, I've taken lawyers to the back. I mean, I had an attorney not too long ago take a pleading and literally throw it at me. Now, that's how I perceived it. Let me say that. That's how I perceived it. I was sitting on the bench. It was in open court. I did not know that my bailiff saw it, but my bailiff saw it as an act of aggression. So as a result, my bailiff came and stood behind the individual, and I didn't see my bailiff initially, but I asked the attorney to come to the back. And in having the attorney come to the back, my bailiff followed. He came into my chambers, and I told the attorney what I thought I saw. I thought I saw you throw a pleading at me. And I don't know what provoked that. I don't know if it's a bad day. I don't know what's going on. And as it turned out, it was a bad day. As it turned out, the lawyer was going through something. But when my bailiff said, yes, you did throw the document, which caused me to come up behind you, that caused the attorney to become very emotional, because I don't believe the attorney knew that the bailiff saw that. So at this point, I asked the bailiff to leave, and the attorney and I had a one-on-one conversation. And I explained that, we go through life and things happen and people get upset, but, I can't tolerate that and won't tolerate that. And so the attorney was very apologetic, but it's, of course, insisted that I didn't see what I saw, but okay, I let that slide, and I said, okay. But if the attorney had not, at some point in that conversation, expressed that, I apologize, I don't generally act this way, I think I would have been forced to take it to the next level. But like I mentioned, even that's probably the most, that's the worst example I can come up with, but in my career. But even at that, I did not go there, because I recognize people are human, but I also made sure that attorney knew and understood that going forward, that I am showing mercy today, but going forward, if I have any inkling of that occurring in the courtroom, I am going to take appropriate action, and they would have included, perhaps making a formal complaint. But I've not had to do that in my career, and I'm glad of that. And I really try to show mercy. I bend over backwards, because I do understand people are human.
Is there that, from your standpoint, when that kind of behavior happens in your courtroom, you certainly are making a point in open court that that's bad behavior? I mean, and sometimes the concern would be if we don't say something and we just address things in the back, maybe we're not doing that. But how do you do that in open court, and where do you draw the line between this is going to be discussed in open court, this is going to be discussed in chambers?
I have had a situation where, and sometimes I'll jokingly say, you didn't mean that, did you? That way everyone knows, and it gives the attorney an opportunity, or the litigant an opportunity to sort of say, well, oh no, Judge, I didn't mean that, or I didn't mean to do that, or whatever the case may be. So I try to give people every opportunity, because I want to make sure that I saw what I think I saw and heard what I think I heard, because sometimes I could be wrong. So I always sort of question, but I try to sometimes diffuse the situation with a little humor. I'll interject something sort of humorous. You didn't mean that. Counsel, I think that you threw that at me, but you didn't mean to do that, did you? Something like that.
All right. And I'm going to push a little bit harder. And I know you said you haven't gotten to this point yet, thankfully, but is there a type of behavior that would cause you to report someone to the bar versus impose sanctions, or do both? How do you make that decision when behavior is getting, completely out of hand?
I think a good example, let's flip it, let's take the pressure off lawyers. Let's talk about litigants. A litigant that looks at a judge in the face and curses. Had that happen. only had it happen one time in my career. After 23 years of wearing a black robe, a litigant looked at me and said, F you. At that point, without hesitation, told my bailiff to put him in cuffs and, you know, he was going to be held in contempt of court. So I think that's where the line is. When it's direct criminal contempt, it is direct. It is no doubt about it. When you say use, you know, those types of words in the courtroom directed at clerk, staff, me, yes, that's it.
Thank you. I got another question, and it's about behavior that's maybe a little more on the other side of the pendulum, and that's the behavior of opposing counsel that repeatedly does what my kids did as teenagers on a regular basis. It's the famous eye roll, combined with maybe making noises, shaking their head on a regular basis anytime opposing counsel says something. It might not be seen by the judge, but it's seen by counsel. Any suggestions about how they should respond to that?
I have a conversation with my bailiff. I typically advise my bailiff about that potential situation. And on occasion, I've seen my bailiff walk up to the counsel that's doing that. And when I see that occur, and if I'm told that it hasn't stopped, then I think that at that point prompts me to say, hey, can you come back and talk to me? Let's talk about this. What's going on? But typically, I take very seriously the box theory that was put forth by McCormick Wilson. Judge McCormick Wilson was a longtime municipal judge, which he was Judge Paul Wilson, his father, and his position was on the box theory. And as a judge, I try to stay in my box, and I think certain things I sort of put in the box with the bailiff. I mean, if you see someone being disrespectful, taking the demeanor of the decorum of the courtroom down to a certain level, I want you to jump in. I want you to tap him on the shoulder and say something to him. So I kind of put the bailiff in that box to some extent. But when I see it directly, I deal with it directly.
All right. Now, Judge Hardin-Timmons, you know that whenever you and I are together and at lunch, all we do is talk about the Constitution and various, new statutory provisions and some of the most updated case law. But I was wondering if you experience discussions with other judges about bad behavior by attorneys in the courtroom.
Yes, certainly. That is some of attorneys. I know attorneys know this, but I guess this is an opportunity to remind everyone is that judges do talk about this, and certainly it's sort of it's an opportunity to let your colleagues know that you could have a situation. So you just don't want to have their reputation. But yes, judges do talk about that type of thing.
All right. You talked about there was some on the list that you provided about the idea of mentoring and how young lawyers should be thinking about that. Any thoughts about how a young attorney could go about seeking a mentor?
Yes, I think that every older attorney, judge, I think they would welcome that. I think that I will tell you that, I like to think I'm young, but I've been practicing since 1989. And anybody who's willing to come talk to me and wants me to give them what I think about something, I'm happy to do that. And I can tell you that I believe that every judge sitting and retired would be happy to do that. I think it's important that young lawyers, when they come out and hang out their shingle, that they get someone that they can bounce things off of, that they can go talk to about the practice of law, because the practice of law it involves relationships. And in order to keep clients and to be respected in the legal profession, it's important that you treat people with civility and professionalism. And sometimes that's not something that young lawyers, get to talk about a lot. So talking to older, more experienced and seasoned attorneys, they can impart that information and sort of say, I know you know the law, I know you're a zealous advocate, but why don't you approach it this way? I think that opportunity is out there, and I think that I know that every judge I know, and I'm certainly willing to have a conversation and offer mentorship to anyone who's willing to ask me, and I'm willing to be there.
And sometimes I know in just discussions with a lot of attorneys, it is important to not only have a mentor perhaps in the firm that one works in, but to have someone that's outside of the firm, because sometimes there may be behavior that occurs in the firm that you feel uncomfortable talking about with anyone within the firm. Not saying that that happens or is that necessary in most situations, but to always know that there are opportunities to reach out to many of us to help in that regard.
That's perfect. Yes, I think that's wonderful. And I really am appreciative of USA&M for having me speak today, because it's an opportunity to speak with a different group of attorneys about this important issue. Civility is really a big deal, and it's important that we just sort of remember, to treat people like we like to be treated. And when we give respect, we receive it back. And everybody's watching. The judge is watching, the clerks are watching, and the litigants and the public, they're watching.
Just one of the things that you mentioned also that many people might not think about that involves in civility is punctuality. Just wonder if you could talk about that for a second.
I think it works both ways. As a judge, I really work hard to start dockets on time. If I say 9 o'clock, I started at 9 o'clock. There are some few exceptions, obviously, but I really work hard at that. I think it's important, though, lawyers, that you be present. And I understand, having worked in private practice for 19 years, you have schedules, you have things scheduled at the same time. All it requires is picking up the phone and calling the clerk and saying, I am going to be late. Could you please inform, the judge of that fact, and also reach out to opposing counsel. That is civility. That is being courteous. That is being respectful. And it goes a long way.
Judge, I have one last question for you, and that involves something that maybe we saw a little bit of a change perhaps during the pandemic. Can you address the dress code, the idea of coming to court perhaps not looking completely like an attorney, shall we say?
I will tell you, during the pandemic, I'll briefly just tell you that there were many attorneys that took the opportunity to wear t-shirts, baseball caps, and that type of thing because they were at home. And, I had to sort of remind them they were still in court. So even though I was, doing divorces and name changes and orders of protection dockets in my home, I still wore my robe. And I had my bailiff present on Zoom or WebEx. So it's important that attorneys, dress appropriately, even if the hearing is being conducted remotely, because it's still court.
Thank you very much, Judge.
Thank you.
Judge Hardin Tammons and Judge Burton, thank you both so much. Your experience in this area is so important. And, you know, the notion of mentoring and younger lawyers getting mentoring, I think those of us who have a little bit of gray hair, it's really on us to look for opportunities to do some of the mentoring. And I think we have a greater challenge right now than we've ever had, because there's still some remote work going on. It used to be every young lawyer was in the office every day and you could see them over at the coffee pot. And now they're, you know, in their basement offices, and maybe it's a little more difficult to mentor the less experienced lawyers. And I think when we have those opportunities, whether it's within our firms or within the organized bar, that we take those opportunities. But judges, thank you both very much for this terrific program, and makes all of us think about how important it is for us to active in a civil way, both in the courtroom and outside the courtroom, depositions, mediations, arbitrations, etc. So thank you both. Folks, we're going to take about 5 minutes and we'll get set up for the next program.
This meeting is being recorded.
It's my pleasure to introduce Missouri's Chief Disciplinary Counsel. Laura Ellsbury has been on the job for, I think, just less than a month, stepping into the shoes of Alan Pratzel. Laura previously served as General Counsel of the Missouri Ethics Commission, and we're so thrilled that she could join us to talk about our discipline system in a couple of areas. The system itself, responding to complaints, handling client funds, and then a little bit about discipline proceedings themselves. Laura, I know you have your PowerPoint up, and take it away. Thank you so much.
Thank you very much, Rob, and good morning to everyone. I am very honored to be here. I do want to share with you, as Rob mentioned, I'm new on the job, and so this is my first presentation. And I must confess, I'm a little bit nervous. I don't know whether I am more worried about having too much material or not having enough. So I thank you in advance for your patience and your indulgence. As Rob mentioned, I am the new Chief Disciplinary Counsel, and I wanted to give you just a little bit more information about my background. It's a little different. I was in banking for more than 25 years. I worked for Commerce Bank out of the Columbia area before I decided to go to law school. Now, I was not the oldest person in my law school class, but I was almost the oldest person in my law school class. But no regrets about that. And when I graduated, I did go to work for the AG's office for almost 10 years, and then was with the MEC. And then I have been here at the Office of Chief Disciplinary Counsel now since the beginning of 2022. So again, I'm very honored to be here with you. Let's go ahead and get started. So quickly, the things that I'd like to cover with you today. The first is just the disciplinary system itself, what its parts are, and how those different parts work. I think, and it's been my experience in the short time that I've been here, that that's a bit of a mystery to folks sometimes. So I'd like to talk about that a little bit. We also have some slides today that have some tips for responding to an ethics complaint should you find yourself being the recipient on the receiving end of a complaint. We have some suggestions for better practices for handling that. Additionally, I want to share with you some resources for handling client funds. Many of our cases that do end up in front of the court will often involve let me say, the mishandling of client funds. It can be a bit of a challenge. And so there's some information I'll share with you today that may help you in that regard. And then additionally, to sort of circle back to the disciplinary system, talk a little bit about our procedures and our standards. And then if time allows, I'd like to talk about the Rule 5 amendments. As you probably know, Rule 4 is contains the rules of professional conduct. Rule 5 contains all the rules that cover our procedure for handling complaints alleging violations of Rule 4. Rule 5 has recently been amended, and the changes go into effect on January 1st of 2023. And we talk about rules being amended. I would tell you that this was more in the line of an overhaul. All good improvements, some substantive changes, but the rule was generally reordered and reorganized in order to be a little bit more user-friendly. And so there have been quite a few changes. And so if we have time, I'd like to talk about those. Additionally, just talk briefly, if you have questions during the presentation, I believe that Rob Litz is going to be monitoring the chat room. And Rob, if I fail to notice that there's a question, please prompt me. But I hope that you will offer up your questions if you have them as we're going along. I believe our title is A Conversation with the new Chief Disciplinary Counsel, and a conversation takes more than one person. So I welcome your questions. So Missouri's structure for attorney discipline is a little bit different. All states have one, and they share a lot of commonalities, but ours is a little bit unique. Let's talk about it in terms of how a complaint is handled. All complaints come to the Jefferson City office of the Office of Chief Disciplinary Counsel, and our intake team reviews those thoughtfully and makes a determination as to whether there is any jurisdiction. In other words, is the person being complained about a licensed attorney that's under our jurisdiction? And if the facts taken as true would actually be a violation of Rule 4. As you might imagine, we get a lot of complaints about people and about things that don't necessarily fit into that rubric. So that's the very first question is, do we have jurisdiction? And then if we do, and the complaint is accepted, it is then assigned out for investigation. Geography plays a big role in that. Some complaints are handled by staff counsel here in Jefferson City at our offices, but we have regional disciplinary committees that sit and function in the Kansas City region, in the St. Louis region, and in the Springfield region. Those committees, with the assistance of attorneys, special counsel that are hired for that function, will often manage those investigations and handle the preliminary matters themselves in those areas. The investigations themselves, the objective is a determination about probable cause. Is there sufficient probable cause to think that the attorney has violated the rules of professional conduct? There are other parts of the of the disciplinary system that are less well known. One is the advisory committee. The advisory committee is attorneys and lay persons who are appointed by the Supreme Court. They have a variety of duties under Rules 4, 5, and 6 as well. They can issue formal advisory opinions with respect to the rules. They also maintain a list of disciplinary hearing officers that will hear attorney disciplinary matters, and they function, the best analogy is like a clerk or a court. When our matters proceed to litigation, we file them with the advisory committee. And they then appoint the disciplinary hearing panel, and they are heard there. Another important piece is the Legal Ethics Counsel, Melinda Bentley. Now, she may be more familiar to some of you. Melinda serves as clerk to the advisory committee. That's part of her function. And she also offers informal advisory opinions. We have published informal advisory opinions, and they will also talk to folks on the telephone and answer questions and help them with situations if you call them. And we'll talk a little bit later about some formal and some formal advisory opinions that they have previously issued. So in 2021, 2022 is not quite over, so we don't have the 22 numbers yet. In 2021, the Office of Chief Disciplinary Counsel received almost 1,800 complaints. Now, only 662 of those were opened into investigations. And as I previously shared with you, sometimes we just didn't have any jurisdiction to look into those matters. The other thing that you may not know happens, some complaints are referred for basically alternative dispute resolution. Some go to the bar's complaint resolution committee, and then we also have our own informal dispute resolution process. And so many times, based on the nature of the complaint, if it's maybe just a fee dispute, or a dispute involving maybe the client wants their file and hasn't been able to get those documents from the attorney. Many of those cases can easily be resolved with the intervention of a third person that sort of goes between the two of them and tries to resolve it that way. The other thing that on to the next page. Sorry, lost my own train of thought. So of those 662 complaints that were investigated, better than half involved communication. Close second is diligence. And when we talk about communications and diligence, what we're really talking about, frankly, in most cases, is a lack of communication and a lack of diligence, both of which are required under the rules. And those statistics are pretty consistent if you go back and look at our numbers over past years. Those are a lot of the complaints that we get from folks. There are also complaints involving dishonesty, fraud, or deceit, maybe issues involving money. Obviously, fee issues do come up. Now, one thing that you may notice, and we are lawyers, we're not known for numbers, although I am sort of the odd lawyer that likes math and Excel. But you'll see that those numbers add up to much more than 100%. And the reason for that is obviously that many of our complaints will involve more than one issue and will implicate more than one rule. So what areas of law were implicated by all the complaints that were opened into investigations in 2021? Roughly 20% were criminal law and domestic relations, and then much smaller numbers were other types of litigation. And I don't know the statistics about the types of cases in our courts, but I wonder if that isn't reflective of the volumes that are actually handled by our courts in this state. And again, didn't share prior statistics with you, but those numbers tend to stay pretty consistent for us year over year. So in 2021, in total, there were 11 lawyers that were disbarred. There were 16 lawyers that were suspended from the practice of law. 2 lawyers were placed on probation. 44 lawyers were suspended for tax, that is, failure to pay their taxes. 2 lawyers were reprimanded, and 70 lawyers were admonished. So I'd like to point out sort of a distinction here. With the exception of the admonishments, those other forms of discipline are all imposed by the court. And the court obviously has exclusive jurisdiction to discipline attorneys. And so those are all sanctions, if you will, that were imposed by the court. So admonishments are a little bit different. They are a lesser discipline, if you will. What happens, we get a complaint and we do an investigation, and maybe we find there is probable cause to believe that there was a violation. However, based on the nature of the violation, and this language is from the rule, further proceedings are not warranted. And so in those instances, an admonition can be issued either by my office or by the regional disciplinary committees. It is a letter that basically summarizes the facts and the violation. The recipient of an admonition has 15 days to accept or reject the admonition. Now, if it's rejected, then we proceed on to litigation. If it's accepted, that's the end of the matter. And so, as you can see, many cases often are resolved through admonitions. Now, another interesting aspect of that is they are not considered discipline the same way a disbarment or a suspension would be. However, the rules do specifically allow the court to consider prior admonitions if they're considering future discipline. And the court does that. We have a progressive disciplinary system. And so whether you have any prior discipline or any prior admonitions would be something that would be taken into consideration before the court would impose discipline, along with other factors, which we'll talk about a little later. So where do complaints come from? Well, obviously they come from clients, but you don't have to be a client to complain about an attorney. Anyone can file a complaint. Sometimes they come from other lawyers, maybe opposing counsel, maybe not opposing counsel. Some come from judges. We do get complaints from judges. There are rules that address that. You may be surprised to know that sometimes attorneys self-report, depending on the circumstances. One that often comes to mind is maybe an inadvertent overdraft. The attorney will reach out to us and make a report about that. We also get reports from prosecutors. And sometimes complaints come from the news or from media outlets. The rule that addresses complaints, Rule 5.8, says that the Chief Disciplinary Counsel has the power, with or without a complaint, to investigate any matter of professional misconduct. And so we are not necessarily limited to complaints that come into the office from, say, a client. We have multiple sources, obviously. So you're all lawyers. What is the rule about reporting another lawyer? It is here. It's Rule 4-8.3a, and forgive me, but I'm gonna read it to you. A lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate professional authority. And there's that word shall. We're all lawyers. We know what shall means. So how do we interpret this rule with the use of the word shall? There is fortunately some guidance for us that comes in comment 3 to the rule, which says if a lawyer were obliged to report every violation of the rules, the failure to report a violation would itself be a professional offense. Now, I'm going to repeat that. If a lawyer were obliged to report every violation of the rules, then the failure to report a violation would itself be a professional offense. And so, obviously, not every single violation is going to get reported or should be reported. And the guidance that we have here in the comments to the rules that would help you decide whether it's appropriate to file a complaint takes us back to the word substantial in the rule itself. The rule talks about a substantial question as to the lawyer's honesty, and that reference to substantial refers to the seriousness, excuse me, of the possible offense. And so shall is there, but considers substantial. And in the words of the rule itself in its comments, a measure of judgment is therefore required. Another aspect of reporting another lawyer that you might need to consider is your client's confidences. You know, let's say, for example, it is opposing counsel. You've obviously got a client. You have that client's confidences, obviously, which you're required to protect. How do you reconcile the need to report, the importance of reporting, if, let's say, if there was a substantial violation, and your client's confidences? And comment 2 to the rule gives us the answer to that. It says that that a report about misconduct is not required when doing so would actually be a violation of Rule 416, which is the rule that requires you to keep your client's confidences. So hopefully that guidance there sort of reconciles the difference there. Now, the comment does go on, as you can see, to suggest that the client should be encouraged to allow the disclosure. But that's a conversation, obviously, between you and your client. So what if the complaint, so what if someone complains about you? What should you do? It does happen, and it's you know, concerning, obviously, and we understand that. So the next couple of screens, we have a few pointers that have been developed over the years and through our experience, some guidance that we can offer to you. The very first thing that we would suggest is open the letter. I've had many people talk about the alarm of receiving an envelope in the mail with the return address of the Office of Chief Disciplinary Counsel. It's not always about a complaint, but even if it is, you need to not be afraid to open the letter. Open the letter and see what it says. You'll want to respond, and you'll want to do it in a timely manner. And if you need more time, we are very generous and very gracious about that. You just need to call us and ask us and let us know that you need a little more time. You know, some complaints are as I like to say, wide and deep. They cover a lot of territory. Some are pretty straightforward. And so it's certainly understandable that there could be circumstances where you would need a little bit of additional time. And we are fine with that. You want to, in your response, be responsive to all the matters that were raised in the complaint. Now, one thing that you won't know at this stage is which rules are being implicated. So this is really just a factual inquiry at this stage. So stay focused on the factual allegations that are raised by the complainant. And I will tell you, size matters. It's the same as when you're filing something with the court. You can overwhelm the recipient and maybe harm your case. I mean, certainly we're going to review everything that you provide us, but if you provide succinct information in a reasonable volume, it definitely helps us move forward with investigating your case. Additionally, and maybe it goes without saying, but you want to be truthful and you want to be candid. Not a time to be lawyerly. you know, if you not time to play hide the ball. So you need to be truthful and you need to be candid with us. And be sure that within your explanation, you provide us details about the mitigating circumstances and the exculpatory facts, the information that we need to know. And you know this also, it's not part of the screen, but we can always come back and ask for more information. We can always call and have a conversation or have you in. We can ask for more documents. There's always an opportunity to follow up and to get more information. And that's what we're going to do when we need to. When we need more information, when we need to understand, then we will follow up. Some other things that you should consider. Do you need to hire an attorney? You know, you may not immediately think about that because you are an attorney. But I think there's an old saying about attorneys who have themselves for a client, and I won't bother with misquoting it. I think we've all heard it. So, you know, give that some thought though. Check with your, you know, the others in your firm or in your office or your friends. You know, get some thought, but do give that some thought before you even respond to the initial complaint about whether your interests would be better served if you had an attorney representing you. You also want to take sufficient time to review the file, make sure that your facts are accurate before you respond. This is a big one. Try not to unnecessarily be critical of the client or the complainant. It's not going to help in any way, shape, or form. And don't assume that everything's going to eventually come out. Assume we need to know. It goes back to the previous slide. You want to provide relevant and concise response.
Hey, come on back.
Pardon me?
I think someone
Okay.
would go right ahead. If everyone would mute, that would be great. Thank you.
All right. Excuse me. So, some final points about responding to an ethics complaint. You know, we already spoke briefly about your duty of confidentiality to your client, a duty that is encompassed in the rules, right? What do you do if you need to share client information or client confidences and able to adequately respond to the complaint? Rule 416B3 includes an exception for confidentiality when it's necessary to establish a defense to a disciplinary inquiry or a proceeding. And I would share with you also, you know, our investigations, our complaints and our investigations are completely closed, utterly confidential. And when we do, if we do, move forward with a case, we have the opportunity, and we frequently do, file documents under seal, redact pleadings in order to protect confidential information. And so knowing that and considering the rule, you should feel comfortable sharing with us what you need to share with us in order to respond to the complaint. A couple of other little things that you may want to think about. You may want to contact your professional liability insurer. They may need and want to know, and they may be able to provide you with some assistance. And the final thing that I want to touch on is you need to think about how you're going to continue to represent that client. Assuming it's a current client that has filed a complaint. That's a tricky one. I don't know that I have any guidance for you. I think it's going to depend on the circumstances, but you certainly wouldn't want to stop communicating with that client. You obviously have a duty to represent them, and understand that can put you in a difficult spot. So take the time and think about that at all, when you receive a complaint. All right, so let's switch gears a little bit and talk about client funds and money. The old banker in me relates to these concepts about money. And so this screen is titled The Ethics of Non-Refundable Fees. And honestly, I probably should have titled it The Myth of Non-Refundable Fees. Non-refundable fees in the state of Missouri are considered unreasonable, and unreasonable fees are prohibited under the rules. Specifically, Rule 4-1.16D requires that unearned fees be refunded at the conclusion of the representation. So if a client paid you a retainer or advance fees, and those were not all earned at the end of the representation, lawyers are obliged to return the unused portion. The other scenario where this comes into play is if the representation terminates prematurely. You and the client part ways for one reason or another. The lawyer is obliged to evaluate what fees have been earned and refund any portions that have not been earned. So to the extent a lawyer would attempt to draft an agreement, a retainer agreement, or a contract for services with the client and state that the fees are non-refundable, that is prohibited. And I've got Formal Opinion 128 is a very good opinion, and it's a formal opinion that was issued by the advisory committee. You can find a copy of it at, I'm going to give you the website. It's mo-legal-ethics.org. Again, mo-legal-ethics.org. And you'll find formal opinions there and also informal opinions. But that particular opinion is a very good read, walks through the analysis much more thoroughly and thoughtfully than we've done here today, but it is something important for attorneys to be aware of. So you say, Laura, what about flat fees, right? Because flat fees are not prohibited, but what you've got to consider is, again, the circumstance where if the representation terminates prematurely, then the entirety of the flat fee has not been earned, and some refund of some portion has to be made to the client. So how do you handle flat fees? They have to be deposited into the attorney trust account, and they can only be withdrawn as they're earned, or if they also are meant to cover expenses as those expenses are incurred. Now, there is an exception, and that is part of the rule, actually. And if a flat fee does not exceed $2,000, that flat fee can be deposited directly into the lawyer's operating account. It does not have to go through the client trust account. But basically, the takeaway is that a flat fee is not earned immediately upon receipt. It's not earned until it's earned. And so there is some special handling. There is an informal advisory opinion here, 2018-15, and that is available, again, on the molegalethics.org website, and you may want to consult that if you've got questions about handling of flat fees. Credit cards also present some unique challenges for attorneys. Obviously, you've probably got to accept them. Many clients are going to want to pay with a credit card, but many credit card processing companies are going to want you to run all of your credit card transactions through a single account. So that would be receipt of all the payments coming in, and also the fees that they're going to charge you for handling your credit cards. And that could present some real problems with your client trust account, because you're basically, you can't let the credit card company debit those fees out of the client trust account. Those are client funds being held in trust. And so you're going to need to find a credit card processor that understands the unique aspects of client trust accounting under Rule 4 in Missouri. This particular informal advisory opinion here, 2014-05, will walk you through the permissible methods for handling credit cards, when the funds have to go to the client trust account and when the funds are permissible to go to the operating account. So again, available at mo-legal-ethics.org. Is where you can go to read that opinion and get some guidance in that respect. All right, the self-audit. Client trust accounting, most of the requirements are encompassed in Rule 4-1.115, and not surprisingly, it's a lengthy rule and it has a lot of moving parts. As I've been doing this work here in this office for the whole of 22, I've come to think that, and this is based on my own ignorance as well coming in here, I worry that there are many lawyers that reconcile their client trust account bank statement when it comes, know they're not stealing their client's money, keep a little extra money in there just in case so they never have an overdraft, and therefore believe that they're probably good and complying with the rules of professional conduct. And unfortunately, the rules require more than that. And the self-audit for lawyer trust accounting is a really good way to walk through what those requirements are and think about them in the context of your own practice and determine whether you are in compliance or not. You can find a copy of the self-audit on our website. That's www.mochiefcounsel.org. I don't know why we're not OCDC, but it's mochiefcounsel.org. And there's a search box, and you just search for self-audit, and that document will come up. I certainly won't read the entire thing to you, but I do want to just walk through briefly the different sections that are in there to give you some sense of what's covered. The first section talks about setting up your IOLTA account, making sure that you are at a bank that's authorized to handle IOLTAs, making sure that account is titled correctly, making sure you have an IOLTA if you're required, or that you have a proper exception to the rule that requires the IOLTA. There's a section on handling the receipt of money and bank deposits. There's a section on disbursements, how those are handled. There's a section on records, what records are required, and there are a lot. That may be the one thing I've seen. Folks don't necessarily, attorneys do not always maintain a general ledger, a client ledger, and then all the supporting records. And those are all required in order to do a proper reconciliation of the client trust account. The self-audit also goes through routine practices, the things that are required, talks about some prohibited practices, talks about the rules, and talks about security in general sense, where you, who has access to the checkbook for the client trust account, who's authorized to sign on the client trust account, those sorts of issues. And then just finishes with some acknowledgement, some understanding about the various requirements that are in the rule. So I know many of us, I personally have never had to have an IOLTA account. I've always worked for the government or for an entity that did not handle third-party funds. So I don't have any personal experience that way, but for those of you that do have a client trust account and do have to manage smaller firms, solo practice firms, I really would encourage you to take the time to print out the self-audit, run through it. If you find that you are complying with all of those requirements, you'll be very contented and very happy with that information. And if you find you can't answer all those questions, then that will help you in order to amend your practices and get in compliance with the rules. All right. I'm switching gears again. Sorry, it did not feel like it was jumping around when I first laid out these slides, and I see now that it is a little choppy, and I do apologize for that. I mean, I think my hope is obviously that I will get better at this with practice, and I appreciate you being present for my first time out. So this slide goes into the conversation, and I want to spend a little time here about how the court decides what discipline to impose. It is obviously up to the court, and to the extent they offer written opinions from time to time on these cases, they do walk through this process. And I find it very interesting. So I just wanted to share a little bit about that with you. As you may know, our rules are, at least initially, were modeled after the ABA model rules. And so in many ways, they are, many of them are identical to the model rules, and some we've modified. The ABA has developed standards for attorney discipline that apply directly to the rules of professional conduct. And those standards have us first ask who the duty was to. If a duty was violated, who was that duty to? Was it to the public? Was it to a client? Was it to the court? Was it to the profession? So we look at what duty was violated. And then the second question that we undertake is, what was the mental state of the lawyer? Was this a negligent violation? Was it a knowing violation? Or was it an intentional violation? Then the third factor that is considered is the extent of the injury. Was there actual or potential injury to a client, to the profession, to the court, to the public? And then finally, there are a list of aggravating factors and mitigating factors which can tilt the discipline one way or another, if the mitigators outweigh the aggravators, for example. So I'd like to walk through how this works. So let's say, for example, we're dealing with a violation of the rule on communication, which is 4-1.4, which very briefly says, a lawyer shall keep the client reasonably informed about the status of the matter. Many times clients believe the lawyers have not. So the ABA, the applicable ABA standards would tell us that disbarment is generally appropriate when a lawyer essentially abandons the practice and abandons the client. I mean, that is the most egregious lack of communication that you might have, is the lawyer just literally is abandoned. And in those cases, then disbarment would be the baseline appropriate sanction. A suspension is generally appropriate if a lawyer knowingly fails to perform services for a client and causes injury or potential injury. So it's back to those four factors that we looked at, and including the mental state. A reprimand, a lower level of discipline, is generally appropriate when the lawyer is merely negligent and doesn't act with reasonable diligence in representing the client. And then finally, an admonition is appropriate when the lawyer is negligent and causes little actual or no potential injury. So those would be the baseline sanctions for a violation of the communication rule, and with consideration of the mental state and the degree of the injury. After determining what the baseline sanction is, then the court will go and consider what the aggravating factors are and the mitigating factors are. And I'm not going to read all of those to you. They're lengthy, and you can find the ABA standards on the internet. But it's things like, is there a prior disciplinary history? Were there multiple offenses involved? Is there a pattern of misconduct? How vulnerable was the victim, if there was a victim? The attorney's length of experience. New attorneys are going to be, given more of an opportunity for a second chance than someone who's more experienced in the practice of the law. Those are aggravating factors. And then there are mitigating factors that relate to kind of the reverse: an absence of a disciplinary record, an absence of a dishonest or selfish motive. Maybe there are personal or emotional problems that need to be considered. Remorse, even. Those are all factors that will be considered in mitigation. And that is the rubric that we use and analyze when we take cases up to the Supreme Court. And that is the process that the court walks through when they reach their decisions. And if you ever read an opinion, an attorney discipline opinion, you will see reference to the ABA standards and then walking through this analysis. And like I said, I find it interesting and just wanted to share it with you. One other thing before I go off this screen, two things quickly. One, and I think I alluded to previously, the fact that Missouri uses progressive discipline. Obviously, the seriousness of a violation could shift things one way or another, but generally, if an attorney is repeatedly found to be in violation of the rules of professional conduct, that discipline will accelerate from admonishments to reprimands to probation, suspensions, and eventually disbarment. And so previous disciplinary history is really significant because the purpose of discipline and the purpose of this office, our objective is not to discipline the attorney, not to punish. Our objective is to protect the public. And so, the belief is that first time out, maybe even second time out, if there's a problem, given an opportunity to correct that problem, hopefully the attorney will take advantage of that, and the public will thereby be protected. So this is a little, it's a busy screen, and I apologize for that, but just a little bit about procedurally how our cases work. The question is there sufficient probable cause to believe that the attorney has engaged in professional misconduct? The initial proceedings are before a disciplinary hearing panel appointed by the advisory committee. That panel hears and receives the evidence, issues findings, and makes a recommendation to the court, but it's only a recommendation because, as I mentioned before, the court has the ultimate and exclusive jurisdiction for attorney discipline. The burden of proof for us is preponderance of the evidence, in case you were wondering. And then the other issue on the screen that I'll just mention again is the confidentiality. When we have a complaint, that we have it as a completely confidential matter. Our investigations are confidential. Once matters are filed and proceeding at with the advisory committee, they are public. Our hearings are public and open to the public. But once that matter is concluded, it is confidential again, unless and until something gets filed with the Supreme Court. And obviously, those records are public through CaseNet. So. This is just a little bit more about that. The disciplinary hearing panels are made up of 2 lawyers and a non-lawyer. All the rules of evidence apply. There is very limited discovery that takes place, almost next to none in the proceedings. Most everything is discovered, if you will, through the investigative process. Hearings take place within 60 days of the information being filed, and the disciplinary hearing panel is charged with issuing its decision within 30 days after the hearing has taken place. But because the Supreme Court has the exclusive jurisdiction, these are original actions in the Supreme Court. We brief them and argue them in a manner that looks like appellate practice, but these are original causes of action, and the Supreme Court's review is de novo. So in many ways, the panel's job, I think, is, you could say, is to help the court by gathering the evidentiary record and putting it together in a manner that will allow the court to look at any particular case. So the path, if you will, we have a complaint that goes to an investigation, and assuming it proceeds, it goes to a disciplinary hearing panel, and the disciplinary hearing panel in all likelihood ends up in front of the court. We have a couple of other tools that we use that I want to just touch on briefly. You know, I mentioned that our objective is to protect the public and not to punish attorneys. And so under the right set of circumstances, we will offer an attorney who has violated the rules of professional conduct the opportunity to participate in a diversion program where we can essentially monitor their practice for a fixed period of time. They may be required to find a mentor. They may be required to hire someone to help with their client trust accounting. They may be required to attend Alcoholics Anonymous or see a mental health professional. The objective is to help the attorney improve their practice. And so whatever is required to get there is what is incorporated into the diversion agreement. The nice thing about the diversion agreement is it benefits both the system and the attorney. If the attorney successfully completes the diversion, then the complaint is dismissed and that's the end of it. And these are confidential proceedings. So it would allow an attorney to, who maybe just didn't know any better, to learn better, to practice, to get better, and to address their problems without having any public record of any discipline. And obviously it saves time for this office and for the courts because we're not going through the whole litigation process. So diversion can be a very good tool. It has to be the right set of circumstances, but we do use it when those circumstances are present. A similar tool that we have is probation. Oftentimes, what you'll see more commonly out of the court is the court will suspend an attorney, stay the suspension, and place them on probation. And there will be terms of the probation which they are required to comply with in order to satisfy the probation and return to an active and undisciplined practice. We also can do probations standing alone, if you will. We don't often. But it is a tool that is in Rule 5 and one that is used from time to time. But as I said, most commonly, the court will place an attorney on probation in conjunction with a stayed suspension. Yes, they're suspended, it's stayed, they're on probation. All right, I have just a few minutes left and I wanted to leave just a few minutes for questions. There are 6 additional screens, which we're not going to go over, but I encourage you to look over them. These would be the highlights of the changes to Rule 5 that are taking place at the 1st of January. Some are procedural for us. I would mention a couple that are interesting. If an attorney is subject to is disciplined by another state or another court, they will now be obliged to report that to the Office of Chief Disciplinary Counsel. And on a related note, attorneys who are involved in crimes, convicted of crimes, charged with crimes, are required to report that. At this time, there is no reporting requirement. So that's something new that takes effect the 1st of January. I hope that never applies to any of you. And at this time, we've got just a couple minutes. If anybody's got any questions, I would be happy to try and answer those for you.
Laura, I don't see any in the chat. There's one thing I would ask of you, and that is during this year, we're coming more out of the COVID mentality that we've had. Are there any particular areas within the disciplinary system that practicing lawyers should be more sensitive to because of this remote practice that we have had? Are there particular things that would be more concerning than back when we were all in the office?
Yeah, thank you, Rob. It's a good question. And I think it really comes back to that communications and diligence. It's certainly harder to communicate with a client when you're not having them into your office. Maybe you're talking to them on Zoom. How do you prepare that client before you go to court when it's a Zoom hearing? And as you saw from the stats in this presentation, those are the most common complaints that we get from folks, that they can't get a hold of their attorney, they haven't heard from their attorney isn't doing anything on their case. And so at the risk of beating a dead horse, those are really the issues that I think in many ways were worsened by the COVID environment.
It certainly is a challenge, and we see it in the mediation universe, where sometimes they're meeting with the client as we start the mediation. And certainly best practices is working with clients in advance to set expectations, talk about the process, etc. And I think you're right. It is actually much more difficult where you're having to set up Zooms and whatnot. So that's really helpful. We have just a minute or so left. Any concluding thoughts?
Not really. I tickled that I got this close. As I mentioned at the beginning, I was worried about the time working out, and I speak very rapidly. So I was afraid I would get on here and just prattle, and 20 minutes would go by and I'd be done. So again, I'm very honored that you guys invited me to participate. It's been a great pleasure, and I want to thank you for that.
Laura, thank you. In your first month, it's great to have you and to introduce you to what was at one point about 84 folks on our Zoom. The practical tips are really invaluable for those still in practice. And thank you and all of our other speakers today. My job is so much easier when we have terrific speakers, which we've had, and great topics. Please don't forget to email your eval to Kelly. I wish everyone a wonderful holiday, a happy, healthy new year, a prosperous new year, and we'll look forward to doing these programs in 2023. Have a great afternoon and a great weekend, everyone.